Okay, Esanam, you can share the presentation. Okay. Hello, everyone. So today we are lucky to host Professor Leyla Keser from Istanbul Bilgi University, who is the founder of the IT Law Institute, and she also serves as the Dean of the Faculty of Law at Istanbul Bilgi University. And I must also add that she is also on our board of advisors here at KUIS AI Center. She has been working on IT law related topics since 1998. And today she will inform us about the recently released report by the Council of Europe Ad-Hoc Committee on AI. Thanks, Leyla Hocam, and the stage is yours.
Thank you, Aykut Hocam. Good morning, everyone. It's a great pleasure to be here today. Thank you so much for inviting me for this KUIS AI Talks series. Today, I will give a brief explanation regarding the possible elements or key elements of the legally binding instrument of the Council of Europe, CAHAI, on AI. CAHAI is an ad hoc committee established in 2019, and under the authority of the Committee of Ministers, the CAHAI is instructed to examine the feasibility and potential elements on the basis of broad multi-stakeholder consultations of a legal framework from the development, design, and application of artificial intelligence based on the Council of Europe standards on human rights, democracy, and the rule of law. Fulfilling this task, the CAHAI took into consideration the standards of the Council of Europe relevant to design, development, and application of digital technologies in the field of human rights, democracy, and the rule of law, and also took into account relevant existing universal and regional international legal instruments. And lastly, we took into consideration of a gender perspective, building cohesive societies and promoting and protecting rights of persons with disabilities in the performance of our task. As CAHAI, we published one document which we called CAHAI feasibility study. And based on that feasibility study, our second obligation was to create a framework which reflects the possible elements of the future legally binding instrument on AI. And this will be a convention in the near future, and within this year, we expect from the Council of Europe to establish another expert committee, just because our mission as CAHAI finished as of end of this year. We finalized our mission, and for the 2022, we expect to see more specific and expert committee which has to finalize the draft convention. So today, I would like to give a brief explanation what kind of elements we considered. We work on that. So, Neslihan Hanım, the next slide, please. Thank you so much. So this is the content of the document we created, which shows the possible elements of the Convention on AI. And this convention will be the second legal framework in the world on AI. The first one is the European Union's Data Act, regulation on AI. And the second one is Council of Europe's Convention on AI. So when we look at the general remarks, as CAHAI, we observe that application of artificial intelligence systems has the potential to promote human prosperity and individual and social well-being by enhancing progress and innovation. Yet at the same time, certain applications of AI systems give rise to concern as they potentially pose risks to human rights, democracy, and the rule of law. To effectively mitigate or prevent these risks, CAHAI considered that an appropriate legal framework on AI based on the Council of Europe standards on human rights, democracy, and the rule of law should take the form of a legally binding instrument. Except that legal instrument, CAHAI notes that in order to clarify the other points and to give more detailed guidance to the community, we need also sector-specific additional documents. One important point we considered and discussed a lot is risk-based approach. This is the one of the key elements of the convention, just because when we look at the European Union's laws and regulations, we see more reference to risk-based approach. So we, as CAHAI, accepted the same approach. The legal requirements to the design, development, and use of AI systems should be proportionate to the nature of the risk they pose to human rights, democracy, and the rule of law. Basic principles that enable the determination of such risks, such as transparency requirements, should be applicable to all AI systems. The CAHAI exclude the national defense or pure military use of AI systems from its work, just because the Council of Europe, it is not the Council of Europe's mandate to work on national defense or military use of AI systems. It is the obligation of the NATO, and therefore, when we publish as CAHAI the possible element documents, you see a clear reference which saying that there is no provision regarding national defense or military use of AI systems. But we considered dual use, the military use and civil use of AI systems, and to that extent, we drafted a few provisions. But national defense and military use is out of the scope of the CAHAI's work. And the various legal issues raised by the application of AI systems are not specific to the member states of the Council of Europe, but are due to many global actors involved and the global effects they engender transnational in nature. Therefore, CAHAI recommends that a legally binding instrument of the Council of Europe, obviously based on Council of Europe standards, be drafted in such a way that it facilitates accession by states outside of the region that share the aforementioned standards, which are democracy, rule of law, and human rights. And legally binding instrument of the Council of Europe should take into account existing and upcoming legal and regulatory frameworks of other international and regional fora, in particular the United Nations system, including UNESCO, the European Union, and OECD. The last point regarding general remarks is that the CAHAI thinks that the purpose of an international legal framework should not be laid down any detailed technical parameters for the design, development, and application of AI systems, but to establish certain basic principles and norms governing the development, design, and application of AI systems, and regulate in a consistent and deliberate manner if and on what conditions AI systems potentially posing risks to the enjoyment of human rights, functioning of the democracy, and the observance of the rule of law may be developed, designed, and applied by all types of organizations, including public and private sectors alike. We have other elements regarding object and purpose, scope, and definitions of the future legally binding instrument. Concerning object and purpose of the instrument, CAHAI recommended, in particular, we stated that the aim of the instrument is to ensure full consistency with respect for human rights, functioning of democracy and the observance of rule of law in developing, designing, and applying of AI systems, irrespective of whether these activities are undertaken by private or public actors. And this instrument shall facilitate cooperation to this end by its parties, both at international and domestic level, and that the necessary follow-up mechanisms shall be established. And the object and purpose should underline the need for establishing a common legal framework containing certain minimum standards for AI development, design, and application in relation to human rights, democracy, and rule of law. As definitions are concerned, the CAHAI considered that as a minimum, for example, some definitions should be included in this legally binding instrument. For example, we, instead of defining or say something about artificial intelligence, we use the term artificial intelligence system. And we also use a lot the AI lifecycle, or AI provider, or AI user, or AI subject. And we defined that sort of terms we use within that possible elements document. And there is a clear reference to human dignity and the respect of human rights, democracy, and the rule of law. So the CAHAI considers it's necessary that a legally binding instrument contains legal fundamental principles of protection of human dignity and the respect of human rights, democracy, and the rule of law. Concerning the concept of human dignity, the CAHAI said that the dignity of the human person is universally agreed to constitute the real basis of human rights. And we have also elements relating to risk classification of AI systems and prohibited applications of artificial intelligence. The CAHAI recommended that a legally binding instrument should provide for the establishment of a methodology for risk classification of AI systems with an emphasis on human rights, democracy, and rule of law. The criteria used for assessing the impact of applications of AI systems in that regard should be concrete, clear, and with an objective basis, and the assessment itself done in a balanced manner. In particular, the CAHAI considers that risk classification should include a number of categories. For example, low risk, high risk, unacceptable risk, based on a risk assessment in relation to enjoyment of human rights, functioning of democracy, and the observance of the rule of law. The risk classification will be based on an initial review to determine if a full human rights, democracy, and the rule of law impact assessment, shortly UDERIA, is required, just as the impact assessment itself may have an impact on whether to uphold or change the initial risk classification of the AI system in question. The impact assessment is considered as an element of the overall legal framework on AI systems proposed by CAHAI. Regarding prohibited applications of AI, we call that kind of AI applications as red lines or unacceptable risk. The CAHAI considered that a legally binding instrument should provide for the possibility of putting a full or partial moratorium or ban on the application of AI systems, which in accordance with the aforesaid risk classification are deemed to present an unacceptable risk of interfering with the enjoyment of human rights, functioning of democracy, and the observance of the rule of law. Such possibilities should also be considered for the research and development of certain AI systems that present an unacceptable risk. The CAHAI wanted to draw the attention to, for instance, some AI systems using biometrics to identify, categorize, or infer characteristics or emotions of individuals, in particular if they lead to mass surveillance, and AI systems used for social scoring to determine access to essential services as applications that may require particular attention, taking into account possible legitimate exceptions. A moratorium or ban should, however, only be considered where on an objective basis an acceptable an unacceptable risk to human rights, democracy, and the rule of law has been identified. And after careful examination, there are no other feasible and equally efficient measures available for mitigating that risk, and given the specific sphere of application. The review procedures should be put in place to enable reversal of a ban or moratorium if risks are sufficiently reduced or appropriate mitigation measures become available on an objective basis to no longer pose an unacceptable risk. And we have some elements relating to development, design, and application of artificial intelligence systems in general. The CAHAI recommended that the legally binding instrument should include a number of provisions applicable to all development, design, and application of AI systems so as to enable their appropriate classification in terms of potential risk to the enjoyment of human rights, functioning of democracy, and the observance of the rule of law, and to ensure their compliance therewith with setting out minimum safeguards. These can include, for instance, provisions regarding transparency of AI systems. In line with the risk-based approach, the further provisions should be rendered applicable to AI systems based on and in proportion with their risk classification in order to ensure that the risks they pose to human rights, democracy, and rule of law are duly mitigated. The legally binding instrument should, as a general rule, state that, subject to certain limitations, the development and design of, as well as the research in AI systems should be carried out freely with due consideration for safety and security and in full compliance with the Council of Europe standards on human rights. And the CAHAI recommended also the inclusion of a provision encouraging parties to establish regulatory sandboxes to stimulate responsible innovation in AI systems by allowing for the testing of AI systems under the supervision of the competent national regulator, all the while ensuring compliance with the standards set out in the Convention for the Protection of Individuals with regard to automatic processing of personal data, shortly 108 Convention, and it is amending protocols, as well as with the standards set out in this legally binding instrument on design, development, and application of AI and other applicable standards. To promote a multi-stakeholder approach and in order to raise awareness in society about the impact of the development, design, and application of AI systems, the CAHAI considers it useful to include a provision calling for parties to promote evidence-based public deliberations on an inclusive engagement with that topic. And CAHAI proposed also to include a provision on respect of equal treatment and non-discrimination of individuals in relation to the development, design, and application of AI systems to avoid unjustified bias being wheeled into AI systems and the use of AI systems leading to discriminatory effects. For the same reasons, a legally binding instrument should contain provisions on ensuring that gender equality and rights related to vulnerable groups and people in vulnerable situations, including children, are being upheld throughout the life cycle of artificial intelligence systems. And CAHAI highlights the importance also to include a provision on data governance for AI systems in accordance with an building on Council of Europe Convention for the Protection of Individuals with regard to automatic processing of personal data, and it is amending protocol. This can include the requirement to establish data governance mechanisms to assess and ensure the data accuracy, integrity, security, and representativeness in a manner that is suitable for the intended purpose of the system and proportionate. And finally, CAHAI recommended the introduction of provisions on robustness, safety, cybersecurity, transparency, explainability, auditability, and accountability throughout their life cycles. And it should be noted that the concepts of transparency, explainability, and accountability are considered by the CAHAI to be of paramount importance for the protection of the rights of individuals in the context of AI systems. And in addition, CAHAI recommended that the issue of sustainability in relation to AI systems throughout their life cycles be considered in a suitable manner. And last point is the future legally binding instrument should include a provision aimed at ensuring the necessary level of human oversight over AI systems and their effects throughout their life cycles. And another point is we also specified different elements relating to development, design, and application of artificial intelligence systems in the public sector. This is crucial for all citizens in relevant country to know that the governmental use or public sector use of AI has to fulfill or provide some legal safeguards to the citizens. So we created a specific provisions and legal framework for the public sector use of AI. And today I would like to focus more a bit technical parts, just because we have a mixed diverse community here. And to discuss the governmental or public sector use of AI, I would like to discuss with lawyers at a later stage at a different conference. So I would like to refer elements relating to democracy and democratic governance, which are important for both technical people and the lawyers. While recognizing that AI may play a positive role in the functioning of democracy and democratic governance to foster inclusive and participatory processes, the CAHAI is also concerned about the potential use of AI to unlawfully or unduly interfere in democratic processes. The shaping of public opinion through AI, as well as potential chilling effects arising through the use of AI, should therefore be considered in the context of a possible legally binding instrument, whereas more specific issues regarding election manipulation, such as micro-targeting, profiling, and manipulation of content, so-called deepfakes, could be dealt with in more sectoral instruments. The role of private entities, for instance, online platforms that help shape the public sphere, should also be considered in this respect, insofar as the growing concentration of economic power and of data could undermine democratic processes. In this context, CAHAI underlined the need for respecting the right to freedom of expression, including the freedom to form and hold opinions and to receive and impart political information and ideas, and the right to freedom of assembly and association, with the aim of ensuring that all parties and interest groups have access to democratic processes in equal conditions, and that a free space for public debate can be ensured. We have also some elements relating to safeguards to be applied to all applications of AI systems used for the purpose of deciding or informing decisions impacting the legal rights and other significant interests of individuals and persons. So these safeguards should at least include the right to an effective remedy before a national authority against such decisions, the right to be informed about the application of an AI system in the decision-making process, and the right to choose interaction with a human in addition to or instead of an AI system, and right to know that one is interacting with an AI system rather than with a human. Other safeguards may be relevant depending on the specificities of the AI systems being used. And the last point is CAHAI is of the opinion that a legally binding instrument should also include a provision on the protection of whistleblowers in relation to the development, design, and application of AI systems, which potentially could adversely impact the enjoyment of human rights, functioning of the democracy, and the observance of the rule of law. And regarding civil liability elements, we don't have any specific provisions. We left this topic to domestic laws, the national law systems. So regarding AI and civil liability, we have today Zeynep Ülkü Kahveci from Bilgi University. She's working on that topic, and maybe KUIS AI organize another KUIS AI talks with Zeynep to discuss in detail the civil liability and AI relationship. So I would like to give a few information about elements possible additional legal instruments. So to that extent, I would like to talk about human rights, democracy, and the rule of law impact assessment. Shortly, we call that HUDERIA. The CAHAI considered it useful and necessary to supplement a legally binding instrument with a non-legally binding model for assessing the impact of AI systems on the enjoyment of human rights, functioning of democracy, and the observance of the rule of law. A well-conducted human rights, democracy, and the rule of law impact assessment can advance the assessment of how the deployment of AI systems can affect the enjoyment of human rights, the functioning of democracy, and the observance of rule of law. The HUDERIA actually should not stand alone, and it should be supplemented at the level of domestic or international law by other compliance mechanisms, such as certification and quality labeling, audits, regulatory sandboxes, and regular monitoring. It is important that the HUDERIA is aligned with such other compliance mechanisms, as it would be unjustifiably costly and burdensome to require human rights, democracy, and the rule of law impact assessments that diverge from public supervisory or regulatory approaches laid down under domestic law. In addition to compliance mechanisms, it must also be ensured that effective remedies remain available for those who may be adversely impacted by the deployment of AI systems. Regarding HUDERIA, CAHAI recommended at least the 4 main steps be included in a human rights, democracy, and the rule of law impact assessment, subject to an initial review having been conducted and including stakeholder involvement where relevant. So the first step is risk identification, identification of relevant risks for human rights, democracy, and the rule of law. To that extent, I would like to explain the discussion between CAHAI members regarding the risk-based approach and rights-based approach. So some of the members of the CAHAI objected to use risk-based approach. According to them, the Council of Europe's standards are human rights, democracy, and the rule of law. The CAHAI deals with that topic. So, in order to clarify or reflect our mission directly, we should have to use rights-based approach instead of risk-based approach. But this was internal discussion between CAHAI members. But to me, it is good to say that we focus rights-based approach just because there are human rights, democracy, and rule of law. There are fundamental principles. So we analyze the risks regarding that 3 important standards. So first step is risk identification. And the second step is impact assessment. At this stage, we have to assess the impact, taking into account the likelihood and severity of the effects on those rights and principles. The third step of the HUDERIA is governance assessment. At this stage, we have to assess the roles and responsibilities of rights holders, stakeholders in implementing and governing the mechanisms to mitigate the impact. The last step is mitigation and evaluation. We have to identify of suitable mitigation measures and ensure a continuous evolution. And regarding the impact assessment step, CAHAI recommended that the assessment of an AI system at least could include following elements. Assessment of the context and purpose of AI system, level of autonomy of the AI system, underlying technology of the AI system, usage of AI system, complexity of AI system, transparency and explainability of the system, and the way it is used, human oversight and control mechanisms for the AI provider and AI user, data quality, system robustness, security, involvement of vulnerable persons or groups, the scale on which the system is used, its geographical and temporal scope, assessment of likelihood and extent of potential harm, the potential reversibility of such harm, and whether it concerns a red line application as established by domestic or international law. The CAHAI noted also that whereas the impact assessment of AI systems is relatively straightforward in relation to human rights due to the existence of clearly defined and universal obligations in this area, the impact assessment of AI systems on democracy, rule of law, may prove more difficult in some cases. Nevertheless, given the strong interlinkage between human rights on the one hand and the democracy and the rule of law on the other hand, in some situations, a negative impact on the former can also provide an indication of a negative impact on the latter. For instance, when the right to freedom of assembly and association or the right to free elections is hampered, it hampers the functioning of democracy. In the same way, an interference with the right to a fair trial negatively impacts the rule of law. And furthermore, other elements can also be considered, such as the purpose and function of the systems within a democratic society, its application domain, and the way it can hamper certain democratic and rule of law principles, such as principle of legality, prevention of misuse of power, or judicial impartiality and independence. And finally, CAHAI is of the opinion that stakeholder involvement in the impact assessment should be assured. The more severe the impact is deemed to be, or the larger its scale, the more extensive the stakeholder engagement should be. In this regard, particular attention should be paid to involving external stakeholders and members of society who could potentially be adversely affected by the development of AI systems. And the last point is we have complementary elements relating to artificial intelligence in the public sector. To that extent, I would like to say that within CAHAI, we created 3 different groups, and the legal frameworks group was responsible to create that draft convention and that possible elements we discussed today. And the policy development group was responsible to create more non-legally binding documents, such as AI use in public sector, or HUD area, the framework of the HUD area, human rights, democracy, and the rule of law impact assessment. And the last working group of CAHAI was CAHAI Consultations and Outreach Group. It was responsible to create stories, etc., and reach more stakeholders to discuss that points with other stakeholders outside of the CAHAI. So I would like to stop here and would like to give the floor to you for Q&A. Thank you.
Thank you, Leyla. So I have a couple of questions, but let me first ask our audience. Yeah, I see Gözde raising her hand.
Hello. Thanks a lot, Leyla Hocam. It was really interesting to hear about these topics. So I'm an NLP researcher in natural language processing, and there are some research going on how to tackle this interpretability, explainability, and the gender bias, fake news detection, and so on. There are just too many topics revolving around this EU AI Act. So, but I'm not familiar with the law part. So that's new to me. So that's why I would like to ask a couple of questions to clarify, like, who are the participants of CAHAI? Are there any AI researchers, or is it just lawyers talking about the EU law and so on? And what happens, like you assess the risks and there are some government assessments, then you're planning on mitigation evaluation. And I think you really need AI experts to do that. Like, who's going to do that? And what happens if these laws are violated? Is there going to be like a European Court of AI law? Are we going to get executed? So what's going to happen?
Thank you, Jose, for these questions. These are really important. The first question, I can say that at the CAHAI, we created really a diverse group of experts, and the Council of Europe consists of governments, the countries, the representative of countries. So the representatives could sometimes lawyers or technical people or governmental representatives. But except that, the governmental institutions and their representatives, we had really wonderful NGOs, representative of NGOs. We have observer countries, such as United States and Canada, which are not Council of Europe members, but they have observer status and they can join the discussions. And on the other side, we have the technical bodies, technical organizations, such as IEEE, ISO, and we have also private sector companies, such as Microsoft, Facebook, Google, etc. So at the CAHAI, we work with all kinds of stakeholders who has sort of interest to see how the things develop at the CAHAI's end, just because we create a legally binding convention for the countries. And these legal framework are important for other stakeholders too. So we have academia also. For example, the Alan Turing Institute or Oxford Internet Institute. They actively join the discussions. So the Council of Europe and the CAHAI was open to everyone. Even Istanbul Bar Association had the observer status and they joined also the discussions. So this kind of organizations can join and say something about the discussions, both on legal and technical part. European Union, they also published a draft proposal on AI, which is the European Union's regulation. It will be a regulation for the European Union member states, but it is the second legal framework on AI around the world, which is also important. And for the regulation, it is possible to put penalties or other administrative fines if someone violates the rules and obligations. But for the conventions, this is not possible. The conventions can create a very clear legal framework. And in order to create penalties or other sort of administrative fines, it is the obligation of the member states or member states of the Council of Europe to draft a new law on AI and put specific provisions regarding penalties and other sort of administrative fines. So we don't have any administrative fines or penalties. It is the obligation of the parties.
Can I interrupt just? So who's gonna decide if an AI is violating a regulation? Because I think AI it's really easy to hack. That's what I mean. I mean, it's really hard to come up with some exact measures to say this AI tool is 60% interpretable, this AI tool is 80% not non-biased, or to have this exact measures? Are we gonna have humans to evaluate that? Like, will a human interact with the tool, or are we gonna build some automatic measures to do that? What is the plan, or is there any plan?
According to the Council of Europe CAHAI, the human is our priority. So we put human in the center of all sorts of discussions regarding AI systems. So during my speech, I also referred human oversight and algorithmic audit, or ongoing risk assessment, ongoing HUD area. And in order to conduct an HUD area, or in order to conduct algorithmic audit, we need human, and we need human oversight. So human oversight is one of the essential, one of the important rule we added to that draft convention. So human in the loop, or human on the command, etc. There are some certain discussions or definitions, but the AI systems has to do something for the social good, or to respect the human dignity or other rights of the humans. So we created a framework to give the control for the human, not the automated systems, etc. So human first approach we accepted, and to that extent, the human oversight is one of the essential fundamental principle of us.
So may I jump in, because I have also a similar type of question. So Leyla Hocam, you mentioned this issue of gender bias, for example. So in our case, usually the data we use to train our models, especially, for example, for deep learning models, the bias exists in the data we use to train these models. And for some cases, even especially large research groups even did not make their training data public. So in addition to this, our science, deep learning is an empirical science. So usually once the model is out there, it takes some time to identify these sort of issues. So for me personally, I think the regulation should be more on the side about this data preparation, sharing this with the public, because we see, again, many different ways of doing this. Just to give another example, for example, we have Tesla, who tests its autonomous driving software, collect the data. We don't know what exists there, what mistakes did it make previously. So I want to take your opinion on this data collection side.
We discussed that point at the CAHAI under the topic of data quality, which is important to create the more safe or respected AI systems in relation to human rights, democracy, and the rule of law. So in order to ensure data quality, it is important to work not only as engineers, but we have to work together. So in order to understand what is discrimination, or what sort of data could create sort of problems, it is a bit difficult for engineers to determine or decide that. But with lawyers or other social science background people, if we work together, we can discuss that point together, and we can clarify that matter easily. Just because as lawyers, we know what is discrimination, what are the problems regarding gender diversity, etc. But for the engineers, They just look at the data sets, etc., and they accept it. Maybe you can just look. There's a data protection problems or IP problems, intellectual property problems at that data set. If you answer, no, there is no problem, it is the public data and it's not personal data, or there are no IP problems regarding the data set, you can start to design, develop, and implement the AI systems. But for the lawyers, we have to think twice. Are there any other problems except data protection and the IP rights of the data subjects or citizens? So therefore, we created and we worked as multi-stakeholder model in a multi-stakeholder model at the CAHAI, and we have to apply the same rule for all sorts of AI systems work. For example, if we want to design or if we want to develop some AI systems, we have to work in a multi-stakeholder model. Just for the engineers, it is a bit difficult to discuss and understand and remove that sort of data which can create or which could create discrimination in the future or now. So to work multi-stakeholder is important to understand and clarify that points.
Mm-hmm. Thank you.
Gözde?
Yeah, thanks a lot. So maybe I would like to wrap up and ask this the most important question. So right now, the state of NLP and probably computer vision, actually I'm not sure about the CV part, but we are at the stage of recognizing the errors and the potential harms and misinformation of the systems. So every year there's something new for conference and workshop organizers. So for instance, the last couple of years, we have introduced a new section that's called ethical considerations and broader impact. So we keep it optional, but you can talk about how the data is collected. Does it include, for instance, Twitter information or anything that can be biased? What is the intended use of the system? What are the potential misuses? So how can so for instance, if you design a question answering system and if you ask a medical question, you have to warn the user that you might get a false answer and you shouldn't trust it. And then we talk about environmental impact, we'll talk about the emissions and the user studies and so on. But that's the level we are at right now. So I'm wondering how much time do we have until we have really strict regulations so we don't keep that kind of stuff optional. So what does this mean for conference and workshop organizers for future?
Again, good question, but for the legally binding convention on AI, I would like to say within this year, we expect to see a convention. So for Turkey, it means, as you may know, as Turkey, we published a national AI strategy from the government. There is a national AI strategy. Except that national AI strategy, as companies, some of the companies, they develop internal policies regarding the ethical use of AI or responsible use of AI. We have also internal policies at the private sector companies end. But regarding the legally binding instruments for the CAHAI, for the convention on AI, end of this year, we expect to see it finalized. It will be finalized and published with the Council of Europe member states to sign and ratify. If Turkey, end of this year, sign this convention, which is good to sign a convention, but it doesn't create an obligation for relevant country to create a law or other sort of regulations, or in order to harmonize its national law system with that convention. In order to harmonize our law system with relevant convention, we have to ratify it. It means the parliament has to approve that convention, and afterwards, Turkey can create a specific law on AI. So, you know, the legislative procedures in Turkey, it takes more time, and sometimes we see some surprises. In a very short period, we see some laws and regulations. So it is a bit difficult to say how the things develop in Turkey after that convention, after we sign or ratify that convention. But maybe 2023 or 2024, we can see a law on AI like in the EU. One thing we know that the presidency published a communique in 2019 saying that Turkey has to follow the European Union's laws and regulations and harmonize its national law system with the EU. To that extent, when the draft regulation on AI of the EU, if they finalize and if they published, enact that draft as law, and as Turkey, we follow that development also, and we can transpose the AI regulation of the EU into our law system. This is the second. This could be another option for Turkey to create a specific law in line with the European Union's AI proposal. So, but the AI regulation is still draft in the EU, and the people discuss a lot the relevant provisions. So maybe if they finalize it within this year, the next year as Turkey, we can start also to discuss that the regulation of AI and to start something in terms of legislation in Turkey too. So there are two different things. There will be a convention which will come from the CAHAI or Council of Europe, and Turkey can sign and ratify. And if we ratify that, we have to harmonize our law system with that convention. But another important point is the European Union and the Council of Europe has a specific memorandum of understanding in order to work in collaboration on relevant topics. The AI, the CAHAI's mission and the AI Convention is another topic which European Union and the Council of Europe works together. This is important. That means either, or if we harmonize our system to the Convention on AI, or if we accept European Union's regulation on AI, the both texts will reflect almost the same provisions, almost the same approach and thinking. So for Turkey, this is also good, just because we are a member of Council of Europe. If we ratify that convention, we have to create a law. And based on that presidency's communique, we have to follow the European Union's laws and regulations. So if the convention and the European Union's regulation will reflect the same provisions and same approach, it is easy for Turkey to ratify on the one side the convention and on the other side transpose the relevant provisions of the European Union's AI regulation into its national law system. This will be easy. But it takes at least 2 or 3 years to see a more concrete legal framework on AI in Turkey.
Well, that will buy us some time to educate AI researchers and maybe enforce that kind of regulations in academic papers, and to think about that side of research.
Do you know the most of the companies, this being said, they have specific or internal policies, which is good. Just because there are some certain ethical principles or responsible AI principles, which are important. And as the CAHAI and the European Union's Draft Act, they also, the both texts says or underlines the importance of almost the same principles. This is important to know that principles and to concretize that principles during your designing or developing AI systems, to apply that principles into the code. This is important. This is the expertise. And when you see the laws and regulations, it will be easy to compatible with the relevant rules and responsibilities.
Exactly. Yeah. I totally agree.
I mean,
okay, are there any other questions? So maybe I can ask a quick question. So when we hear the experts in our fields, they make this resemblance between like regulating AI versus regulating biological weapons. So when I see your list, some of those might be like replaceable. We can just replace AI with biological weapons. So again, I would like to hear your opinion. What do you think the most important difference or distinct property of AI systems from the perspective of law compared to these similar issues?
This was one of the discussion topics at the CAHAI, the killer robots or the biomedical or sort of weapons based on AI systems. And the mandate of the Council of Europe, because of the mandate of the Council of Europe, as CAHAI, unfortunately, we don't have any sufficient or detailed discussions regarding that points, but just because it is out of the scope of the AI convention we work on. We just focus dual use application, dual use AI systems, both military and civil use AI systems, but pure military use or pure national defense purpose AI systems are outside of our work. But the people, when we discussed that point at the group, the people said that as humanity, we published several conventions, for example, regarding the use of biomedical the weapons or sort of things during wars, etc. There are specific conventions how to use that kind of weapons, or what is within the scope or what are the out of scope. The NATO or UN has specific conventions for regulating that points. And regarding the AI systems, regarding the biomedical weapons or the killer robots, etc., the AI systems used for pure military purpose, this was truly important and for the humanity, and to discuss and to create a legal framework on that, unfortunately was not the responsibility of the Council of Europe. Therefore, we always, we put disclaimer, there is not our mandate to say something about that, but these are important, the AI-based weapons or other sort of the killer robots or else. But unfortunately, we don't say anything else about that, and we don't have any provision just because it is the obligation of the UN and NATO. So within our this discussion group, they also highlighted the importance of that point. We already started this discussion groups or work to frame or to create a framework for that topic too. But this is crucial, not only for the relevant countries, but for the humanity.
Thanks. Thanks, Leyla Hocam. So if there are no other questions, maybe we can thank our speaker again. Many thanks, Leyla Hocam. This was really insightful and informative talk.
I would like to thank you all for joining and inviting me and joining this session. Thank you so much. And within this year, I hope to see that specific committee after CAHAI, a specific committee will establish and finalize the draft convention we discussed today. Thank you.
Thank you very much, Leyla Hocam.
Thank you.
You're welcome. Have a great day. Bye.